Faces and chapters from the Central European legal heritage. Welcome to the Central European Legal Insights, the podcast series introducing the professors of the Central European Academy at the University of Miskolc through insightful conversations with Judit Varga.
So, our Central European societies are not so decomposed as the Western are. And this is the reason why we are still eager to protect our natural communities, families, etc. And we are not so much dominated by individualism. Law is a culture. Law is a creation of society, of social life. And as such, society is creating culture because it is living. It is creating institutions. It is inventing a certain way of achieving certain goals. And I think Central European Academy is also the place where some not uniformed, not homogenized opinions could be met, discussed freely. So it is very, very precious, especially for scholars from Western Europe.
So welcome to Central European Legal Insights, the podcast series of the Central European Academy at the University of Miskolc. My name is Judit Varga and I work as a senior mentor at this academy, and I will be your host in this podcast program. Our objective is to bring you closer the faces and the personalities of the Central European Professors Network, and throughout friendly conversations we would like to present the rich legal heritage of Central Europe, and also throughout some exploration of stories and ideas beyond science, we would like to point at our common values here in this Central European region, which connects us. So with this introduction, I would like to warmly welcome Professor Dr. Aleksander Stępkowski. He's a professor of the University of Warsaw. He is the head of Department of Sociology of Law at the Faculty of Law and Public Administration of the Warsaw University, but he is a judge of the Polish Supreme Court and also being the spokesperson of that institution. So, dear professor, welcome to Budapest.
Welcome. Thank you very much for inviting me to this podcast and to the Central European Academy, of course.
We are very honored to have you here as a guest. We are facing very relevant and burning issues, which we will be tackling in this approximately 70 minutes podcast. And we would like to concentrate on the main pillars of your academic work, which is ranging from legal theory through European integration and also constitutional identity. And we are also very grateful for your long-standing partnership within the Academy, and also we look forward to having further cooperation in forms of books or publications or conferences. So, dear Professor, let's warm up with some personal questions. Actually, if you allow me, I would like to ask you about your personal background. Why did you choose to become a lawyer, especially in a very specific field, legal theory or sociology of law? How did you end up in this profession?
Well, this interest in theory came much later. First, it was the decision to start to study law. I'm not from the family of lawyers, so it was not an obvious choice for me. But a friend of mine in my secondary school asked me a question: why don't you study law? Because I had a problem with choosing the topic. I was quite a good in many fields, let's say, so I had a problem with making decision, and indeed, I found this idea good. I applied. It was the time when it was not so easy to access the law faculty, but because of my interest in history, and later on it appeared that also in philosophy, I I attached particular importance to those historical and theoretical topics in legal science, and I was always interested in answering question why our contemporary law looks like it looks like. So what is the reason? And reason most often is somewhere in the history. Some our historical choices we made once then determine the development of institutions, development of societies, etc. So in order to better understand our contemporary institutions and contemporary law, it is always good to ask a question about the history, about the roots, about the sources of this current situation.
Well, so this awakening to the importance of this root of law and science of law happened during your university years already.
Yes.
And you have a beautiful career track record, and I also listened to many of your presentations in various conferences. What would you pick from your work as emblematic and very specialized for your own legal scientific character from your works?
Well, I think the interest in comparative law, choosing the topic of my thesis on my PhD thesis, then of my habilitation, I started to ask questions which were better, which the best way to answer was to go into the researching of different legal systems or even different legal cultures. Perhaps it is better to say. So I started, during my studies, I focused much attention on Roman law, for example. And after I have finished my studies, I decided to go into the interaction between Roman law legal tradition and common law legal tradition. So those two big European streams of legal culture, legal heritage, and their interactions between them. Englishmen, they always say that English law has nothing to do with civil laws, how they call the Roman law, but it is of course not true. But it is a very important point of their legal identity. In order to go into those interactions between Roman law tradition and common law tradition, I decided to study Scots law and especially this trusts in Scots law. So these fiduciary relationships, which are so characteristic for
very special.
Yes, for English legal culture. So I decided that this topic, very specific topic, will also allow me to understand how those interactions between civil law tradition and common law tradition took place, because Scotland was always influenced by French culture rather than English one. Of course, they were dependent of England and they started from Anglo-Saxon institutions, but after then, after their struggle for national identity, for their country, they started to emphasize the distinctiveness, and they sent their children to study legal science law in France. So those who came from France, they brought into Scotland Roman law tradition, and it was developed there as a point of their distinctiveness from from England. So I started with private law, private comparative law. The effect of this study. This is my.
You wrote it in French.
Yes, it is elaborated. My PhD thesis translated into French. So, l'institution du trust, dont les droits privés écossais. So, Scots law as a mixed legal system. It was the main topic of my interest. So this field where common law tradition and Roman law tradition are interacting. But after I changed a little bit after my PhD. I changed a little bit my interest and go much more into the political issues. Let's say at the beginning, I decided that I would like to avoid political issues. So I chose the private law topic. But after that, when I was looking on the way of the formation of those different mixed legal systems, because not only the Scots law is this kind of mixture, I realized that everything depends on politics. The wars, the political conflicts.
It will be a nice statement.
Yes.
It's a quotation.
And that was the reason why I started to think much more in terms of political philosophy and looking for important answers for lawyers, but in this political field, more or less. And this brought me to the principle of proportionality, which originates in German legal culture, also Verhältnismäßigkeit-Prinzip.
Schönes Wort.
But then it spread around the European countries and became so important principle for European culture, for European liberal democracies, I would say. I realized that actually it is an expression of some desire of people to preserve as much liberty as it is possible in their situation in relation to state. And so principle of proportionality, actually this is the main issue within this principle. I started to make some comparative studies. I realized once that it's actually about the acceptable way of the exercise of administrative discretion and then legislative discretion. So discretionary power became in the center of my interest, and that was the starting point for my habilitation, so about principle of proportionality as a means of controlling the discretionary power in the modern Europe. And actually it appeared that this issue is so crucial for all the philosophy of statehood in Europe that it allowed me to make some observations which I was able years after to use in Central European Academy within the research, within the project which was undertaken within the professors network about European integration. It appeared to me that we are following certain paths of development, political development, which determine our current situation, political and legal situation, but this is the process which started much earlier, so somewhere in 17th century. And from 17th century to today, we are experiencing one single process, of course with many different phases, with many different, but one latent idea. So this leading motive is within this process performed, and this allows me also to look at some processes which are often discussed in Europe from very narrow perspective, let's say, in a much wider perspective, and to understand better, also to predict some development. If we are speaking about the same process which is lasting for several centuries, then the development is quite better, quite easier to predict.
Actually, this wider perspective in your work has drawn my attention to this practical necessity or possibility. So do you see any impact of your presentations and findings on actual and incumbent decision makers today? Because if you can forecast based on past observations, you can forecast the future. Certain institutions, like let's say the European Union. Do you see any light in the end of the tunnel that you can give important pieces of advice for decision makers, or is it just an observer's position as a legal theorist?
Well, if you are in the long tunnel and you see the light in this tunnel, it might appear that it is a train approaching, and oftentimes the tunnel is too long to make just a perfect idea to leave the tunnel. Yes, because it is impossible to leave the tunnel before the approaching train, for example.
Very good answer.
So politics oftentimes within the situation, which is much more complex, and some other factors must be taken into account, and they influence the decision. Perhaps for this reason, those decisions are not as optimal as they could be, but oftentimes it is impossible to convince the decision makers to refrain from certain way of proceeding. Yes, because they have to be accountable to the wide audience, to the society, and to explain why. And it is not a good explanation because one professor told me.
Well, it was just a philosophical question. So actually, it was through the comparative law background and the European integration as a special legal field when you came across the Central European Academy. So how did you meet us? How did you get in touch with us?
A friend of mine from University in Opole, but working also in Warsaw, recommended me, asked me if I would be open to come with some lectures. I love Hungary and Hungarians, so I accepted, and it started
then
like
we keep going on together. So thank you for that. Well, dear professor, let's dive into the very topics of this discussion. When we were talking about the main pillars of this podcast, we decided to start from the roots. From the very basic questions of law and culture. So this would be the first topic or area, law as a cultural phenomenon and human rights. Then we would like to go to tackle some European integration issues. And at the end, the very important buzzword of today in Central Europe, the constitutional identity. Of course, the special character in Poland. So let's start with the very open and big question of law. What is law, in your view?
Yes, it is fundamental.
Is it possible
question.
to answer this question?
Well,
like moral minimum, what we
is
learned in Roman law, for example, but maybe you have a much more diverse answer for that.
Of course, it is a question of what kind of answer is expected. Yes, oftentimes we are somehow divided in approaching issue of law. If either we consider law as a set of legal rules, yes, rules of conduct, or we are looking for some moral order, ethical order. These are two paths which are most characteristic for for modern legal culture, because it is based on contradiction, and on the one hand we would love to achieve some ideals of some moral, ethical ideal of some substantial principles, but with the certainty which is possible only with the written positive legal rules, and it is very difficult to cope together them. So once we are much more focused on some ethical order, on the other, in other time on rigid, strict written rules. But in my opinion, both paths of looking for the answer on the question of law are not sufficient. Law is a culture. Law is a creation of society, of social life, and as such, society is creating culture because it is living. It is creating institutions. It is inventing certain way of achieving certain goals, etc. And it is, for example, inventing language in which we can communicate. Yes, and the language. What is language? Language is a culture phenomenon. And if you have rules, you have to communicate them in a given language. So in a certain culture phenomenon. If you consider something as a good and something as a evil, it is also determined by your social imagination, what is socially acceptable, what is not acceptable. All those issues are culture phenomena. So if looking for the answer to the question, what is law, I would say law is a culture.
And what is culture?
And culture, it's a complex phenomenon which is allowing society to order the surrounding world in which society is living. It is allowing to make basic distinctions between what is good and what is evil, what is rational and what is irrational. We are ready to discuss topics which we consider as rational, and we are not going to discuss some topics which are irrational for us. Yes, and this is culture which determines what we consider as rational or as irrational, as irrelevant for our social life. And those basic distinctions are allowing us to order the reality, to make some imagination about the world surrounding us. And also law is an aspect of so understood culture, and an aspect which is allowing us to make some order, some distinctions, to say what is proper, what is improper, what is good, what is evil. So we have to research law exactly as a culture. And if we are going deeper into the question, into this determining question of what is good, what is evil, what is rational and what is irrational, and it is a kind of my discovery. It is actually related on our answer on the question or our attitude towards transcendence.
You just had a recent article in French about this.
Yes, indeed.
This finding.
Yes, I consider this finding as one of, at this moment, fundamental for my legal research. Because it allows me to understand better the development of legal culture we witness today. This allows me to make free basic attitudes towards transcendence and towards law.
So 3 attitudes towards transcendence, thus towards law. The 3 different attitudes.
Yes, those 3 different attitudes, they determine the kind of culture we are creating and living in, and then it determines all the institutions we are creating within the social life. So this is the reason why it is so important for law. And the first attitude, it's a traditional, let's say, pre-modern attitude, where we consider that the world is created by the highest reason. And this is the reason why the world is reasonable, because it is coming from the highest reason. And human being, if it is reasonable, it has something in common with this highest reason. Our rationality is of this transcendent, comes from this transcendent source. And this conviction is making us, first of all, we are looking for discovery of certain moral order, rational moral order. Rational and moral are the same, actually, in this attitude. And this is determining for all the intellectual culture then, because it is asking about the being from the metaphysical perspective. And this is the reason why in pre-modern times metaphysics was considered as a first philosophy, as a key philosophy for the development of all other sciences. Yes, and after we lost our convictions about this relation, this link between us, our rationality, and the highest reason, we started we changed our attitude towards transcendence, and we switched into the deistic attitude. So we made an assumption that the world is created by some highest reason, but this highest reason is inaccessible for us, actually. It is not caring about us. It is not interested very much. So what we can do is we can research the physical structure of the creation, and this allows us to gather some certain knowledge, some knowledge which is certain, which is collected by empirical means. And this is modernity. And this modern approach to this modern culture produced also specific modern legal culture, which is based on positivistic approach, because statutory text is empirically easy to know,
to grab,
exactly, and we can read it, and we should know what is expected from.
It's clear.
Yes, it should be clear. At least we start with this conviction that it will be clear,
and then we ended up in questions.
Yes, because earlier in the pre-modern era, we considered that our legal institutions are some extension of general legal order. So is general moral order, let's say. So social conventions were of utmost importance for us, and customary law for this reason also. Then we have rationalized somehow those statutory, those customary rules, and we produced great deal of law by means of interpretation, by means of interpretation of legal scholars, of practitioners, etc. This is the reason why in Roman law we've got digest, which is composed of juris peritis responsa, which demonstrate the way legal rules were searched for and discovered, from starting with some certain social conventions which are rational, which were considered as a rational. Today we consider that if there is that something is a matter of custom, it is oftentimes irrational, whereas they considered that customs are the expressions of our human nature. So if they are expression of human natures and this nature is rational, so those customs should be also rational. And we started with this change somewhere during the Enlightenment, with this change of attitudes in intellectual culture. We started to develop positivistic approach to law, which is actually based on certain contradiction. I've already mentioned that from one point of view we would like to achieve some moral order, natural moral order, but we want to put it into the paper with clear statements of some legal principles, some legal provisions, etc. And once we create our statutes, our codes, we started to find that they are deficient somehow. They should be perfect, but they are not. They are deficient.
Because they are static and life is dynamic.
Yes, and we start criticize those legal provisions which are already existing with some moral arguments that it should be differently regulated. So because of that we make some amendments. Yes, we change the law so that it would be already perfect, but it is again not a perfect one. So modernity is providing us the great dynamism in legal development, because pre-modern era, so this classical legal culture, it was looking for stability. The good law, it was the old law, whereas modernity brings us this thought which was expressed by Voltaire, that if you want to have a good law, you have to burn out all the law so far existing and write a new one, which will be rational, etc. Yes, so so this started never-ending amendments into the legal statutes. But this deistic approach is only somehow it is only per period of transition, because if we decide that there is no rational reason for making any effort to communicate with this transcendent source of our reality, we focus only on this part of reality which is immanent, not transcendent, then we lose any interest in this transcendent reality, and we decide that there is no use to think about some transcendence. So we have to focus only on the matter, on what is material, and abandon any thoughts about some existing highest reason. And this is the very base for our postmodern shift in our contemporary culture, that we started to build our culture and our social institution upon atheistic approach toward transcendence. So the belief that there is nothing behind.
When did it happen in time?
Well, there is no single one moment. If on different stages, if those moments of transgression were different, actually this transgression took place when the modern institutions were mature enough, I would say. They were mature enough, and we realized that we would like to make a step further, even though they seem to be accomplished. And in legal theory, I would place this moment quite early, because in 1920s with Hans Kelsen, who made this transgression from the positivism into normativism. Normativism is not caring about social reality. It is only about two facts which are bound together with the coercion provided by the state. So in legal terms, looking into reality from legal terms, we don't care about what it is. We care only on what it ought to be. And so if the modernity is based on changed the first philosophy from metaphysics to physics, this is the reason why Newton is so important for modern culture. So this link to the physical reality, because we started to build our knowledge upon the empirical science, it appeared that it is not important to pay attention to this empirical reality. It's better to pay attention to what it should be. As I have mentioned, metaphysics was the first philosophy for pre-modern era, physics for modern era, and politics became the first philosophy of the postmodern era. It doesn't care what is the reality, but you care what is the political decision you have to follow.
Sorry for interrupting, but the question arises in me because now you walked us through in a chronological order in these three different approaches based on our relationship with transcendental and the highest reasonable or reason. Can these three different attitudes exist today parallelly, despite the evolutionary fact and the historical fact behind? So can today a lawyer think in a pre-modern style about the actual law, or because the
in
question,
private?
Yeah, in private.
In private, at home.
Because his relationship with the transcendental, let's say God,
yes,
it's very deep.
But
the conviction.
If the lawyer is living home and goes to the law firm, he has to approach the dominating approach,
which is the third one today, the atheistic
exactly.
one.
We are still in a certain transitional period. Yes, we still are using codes, etc. But much more often already we are looking into the jurisprudence, into the case law, then into the
yes, more and more.
Yeah, more and more, because as legislative power was dominating in the modernity, today it is judicial power which is becoming most important, because it doesn't matter what is written in the statute. It matters how it is read by courts, and because courts has the power to impose this interpretation of statute on the rest of society. So this transgression from modern to postmodern. It is also transgression from legislative power into with this emphasis of which was put on the legislative power in mature modernity to contemporary importance of judiciary.
And is there any forecast? Because I assume history will not stop, development will not stop. What is the fourth stage? Maybe what can you see after the atheistic approach?
I think there is no fourth stage. I think these are.
This is disappointing for me to hear.
Well, the question is where we will go back. In my conviction, this postmodern approach is leading us to some catastrophe, and the question is what we will decide to create after. This kind of catastrophe was the Second World War. And we believed that in order to avoid this kind of catastrophe, we have to stick much more to liberalism and democracy. After the Second World War, we decided that liberal democracy is the best what we can do. And today we experience this development of those institutions, which is demonstrating us that there is no future for this kind of thinking about social life, and it is visible, very well visible in demography. Liberal democracies are dying, are older and older, no children, and who is invading us? Those who have children from the countries which has quite a different attitude towards transcendence, and they are able to impose their attitudes upon us if we don't change anything.
And maybe out of this interaction, especially in the western part of Europe, the mass migration of people with a completely different cultural background. Do you see any outcome of this collision of different approaches? Or?
I don't think it will be productive, because we are not going to change our approach towards transcendence because of this invasion, let's say. It is Völkerwanderung, yes. It is this movement of peoples. Yes. So we are not going to change our approach because of that. We are not going to review our attitudes towards transcendence and
human rights.
Reality.
Human rights are often mentioned in these political debates, especially concerning migration, the rights of the individual, people's rights of the third countries to freely choose their place of living. Do you think that there is a different approach to human rights in Central Europe, which is in character maybe special or different to the mainstream Western European approach? Because also we promised to talk about human rights as basics.
There is a certain specificity, which is the outcome of our being separated for quite a long time from Western mainstream, let's say, and we had no conditions for the human rights to take all the effects of human rights already impose on the Western society.
So we need certain stages of involvement or
so
how you
we are not so advanced in this process, I would say, and this is the reason why we are quite specific, because my thesis is, which again was somehow included into one of my contributions to another study of the professors' network. My thesis is that actually human rights and the very concept of right as a subjective right, as an empowerment of individual, yes, the real effect is to dismantle, to weaken and destroy social bonds. So our Central European societies are not so decomposed as the Western are. And this is the reason why we are still eager to protect our natural communities, families, etc. And we are not so much dominated by individualism. So there is the reason for this specificity, but also in Central Europe, human rights are operating in a similar way, but they are not all the social phenomena are not so much advanced as they are in the West.
Do you see it reflected in the jurisprudence of the courts of Central Europe? Because when judges are faced with a certain case of individuals referring to human rights,
it is this question of this Overton window, yes. Overton window. Okay. So this the spectrum of what is considered rational. That some things, some solutions are difficult to be accepted, yes. But so still, perhaps we are not so open for certain instances of individualism. This issue of same-sex couples is very much instructive. Yes, it is. If it can demonstrate, it could be a good demonstration, because family in more traditional, so more characteristic for Central European way, it is something more than cohabitation of two individuals who, through the autonomy of their will, decided to live together. It is a kind for Central Europe. It is much more community, which is something more than just a commitment between two persons, which is open for bringing up children, for giving the life to the children and to bringing them up, so to continue society. It's not. It is considered much more as included into the whole society and not as an autonomous, cohabitation of two people.
I think it is also reflected in the concept of the family in Central Europe. In some countries, it is also included in the constitution. If you just look at the recent amendment of the Slovak constitution, this specificity of Central Europe is still reflected today, not only in the jurisprudence but also
indeed
constitutional level.
Central Europe is in this specific situation that just next to us there is a society which is much more advanced in this process, and we can look at them and make a decision if we are going to follow them, or perhaps we would prefer not to follow them. And all those efforts, Hungarian efforts, Slovakian efforts, also Polish efforts, for example, to protect identity of marriage as a union of man and woman, yes, and everything which is linked to this basic assumption. These are the efforts to protect something which is contrary to the idea that individual with its autonomous will has a right to make changes, social changes, in order to provide for him, her, it, a necessary autonomy to make decisions as she wants.
And does this phenomenon not imply the fact that in these three different approaches towards the transcendence, we are in a different pace of that? Because actually the final stage, which you
we still accept the deistic approach and still don't accept
it's still the modern
atheistic.
one or the pre-modern. So this actually, when I raised the question earlier,
not
is it
pre-modern, modern.
The modern is the second stage. So this is why I asked the question whether is there any possibility today in the world, or let's say just in Europe, to coexist with these different approaches in elapsed timing between countries. If Central Europe is still fighting or still Central Europe likes to be in the second phase and would like to stay here longer or for longer.
Unfortunately, this deistic approach is only a temporary solution. It is only the way to achieve the proper one position, and proper one position is denial of the transcendent highest reason. So there are two basic and one which is actually a transmission from the one
to the
to the other. So I am using often the metaphor of slippery slope.
Slippery slope.
Yes, if you want to climb up on the slippery slope, it is hard. It is possible, but not if you are going to stay in the middle. Mm-hmm. If you climb to the very top and then you leave the slippery slope, but it is impossible to stay for a longer time in the middle of slippery slope. So it is actually, and this process of evolution of the modern culture and transgression into the postmodern is common to the West and Central and East of Europe in this way, that we are accepting the same premises, basic principles. We accept that we are individuals. They accept that we are free and equal. And this is basic assumption upon which our society is based, our institutions are based. So we are in the same family, but of course we are not so advanced in this process. But this is not the question of substance. It is a question of degree. Of the advancement of those processes. I am quite pessimistic in this respect. But I am not trying to be to discourage anyone from taking efforts in this direction. So let's climb on this slippery slope. Perhaps we are able to climb to the very mountain and to start to thinking how to build our social life in a different way.
Well, let's leave this topic with this positive note. You leave room for optimism, and let's move on to the European integration, because from a constitutional point of view or statehood point of view. So you had a very, very interesting presentation at a recent conference in the Central European Academy, where you found some similarities between the centralization of modern states and the federalization of the European Union. And there were interesting, far-reaching questions raised, whether the European Union already exhibits some kind of statehood. So if you could just, in the second part of this discussion, enter into this world. It's very, very interesting, again, from the past evolutionary point of view. Then you are actually based on all your assumptions on historical facts.
This evolution is determined by metaphysical relation. If modernity is based on the contradiction, on inserting contradiction into the being, and this is this is making the being dynamic, and this makes the being evolving as an expression of this dynamism. And the same is about this evolution and this dynamism, inner dynamism, is characteristic for every social institution, modern social institutions. And if we look into the early modern states, how this modern nation state was crystallizing out of pre-modern social order, we can see that first we have a domination of the central executive power, the absolute monarchs and their administration. They started to create public administration, and this centralized center of power was somehow countered by social representatives in the parliaments, which in the early modern times they have no legislative power, but only a power to control the executive. So, but after development of this control, it appears that parliaments could become legislative power, and executive could be subordinated into this legislative power. And if we now consider evolution of European Union, we can see that within the European Union, something which could be taken as executive power, so the Council and the Commission was for a long time dominating, but parliamentary powers became more and more visible and more important. Parliament was included into certain processes, into more processes it was included. And now if we look into this project of the new constitution new treaty constitutional treaty for Europe from 2023 November, we can see that now those positions are changed, and no longer Commission is dominating, but Parliament. And so situation is quite similar as with nation state.
If it's helpful for your research, my own professional background is a mere proof for this theory, what you are just describing, because I had been working in the European Parliament between 2009 and 2018. And through these almost 10 years, I saw this development with my own eyes. And the big trigger was the Lisbon Treaty and the implementation of the Lisbon Treaty. And each and every speech in the European parliamentary hemicycle, not from all political parties, but from the mainstream parliamentarians, started with more power for the European Parliament.
Of course.
And if we look at this draft of the new constitutional ideas for Europe,
exactly implementation.
We ended up where you just
it's because
said.
European Union is looking for its own legitimacy, political legitimacy. So far, they took legitimacy from the governments of the member states. So because of that, the Council was theoretically the most important. But now, Parliament became on a certain stage cased to be just parliamentary assembly, became to be representative of the societies of the member states, and now they are going to make some effect to this change, which took place in the 80s, yes, so quite a long time ago. So they are looking for the autonomous legitimacy to legislate. And they are looking for certain solutions. You have read my paper, so you could see what I have found in this project of the constitutional treaty. But perhaps this way or another way, of course, also the Court of Justice of the European Union is here very much important, because he will look after the observance of the decision made by European decision centers, so also with parliaments. So Court of the Justice of the European Union will strengthen the European Parliament in this respect, strengthen in relation to member states. So in my opinion, European Union is going to emerge into the postmodern over-national state,
supranational
state,
which is often
yes,
one topic of the high political debates. And do we have some hope that the constitutional courts of the member states might prevent this evolution, or may just slow it down? Or it's again the same determinism?
It is always important to have a hope, and so far constitutional tribunals were trying to avoid conflicts, open conflicts between EU and national and nation states, member states. So their jurisprudence was saying that actually this conflict, which might be considered as existing, is not existing because we can find some solution. This solution most often or always meant that member state has to change its own law in order to conform to European. Currently, we've got much more tensions within the European Union, so there are political conditions to stop to say that, oh, there is no real problem, we can cope with this. So there is also some space for articulating this conflict and perhaps to make some decisions in this respect, but it will go counter the main stream of evolution, and it is very unlikely to succeed.
One of my former colleagues described this situation, so the collision of the European law and the constitutional court's interpretation of the national law and the sovereignty, as if an unstoppable object would hit a stable rock. The stable rock is the constitution, the constitutional court, the national identity, and this kind of drive, which is unstoppable, and pushing back and back those.
The question is which is bigger, because physics is saying that the bigger will prevail, and here is the real problem. If it is a question of the existence of the European Union, because it is the inner logic of this creation is to expound into this into the political entity similar to nation state by supranational, national. So I cannot imagine situation where there is existing and developing European Union and still the nation states are as a sovereign states, member states as a sovereign states.
You are coming from Poland, which is a member state of the European Union since 2004, so more than 20 years, the same for Hungary. Those problems or challenges were already seen at the time of accession. So as a legal scholar, based on your 20 years ago research, could you see such a present challenge of the European Union?
Well, I saw those problems, but I was too small man to express this. One professor in Poland tried to write papers on it, but they were hardly acceptable for in leading journals. They were actually rejected. One journal which was quite a new recent and was looking for some fresh papers, it accepted this paper, alarming that this is a very risky endeavor. But it was strict minority situation. We have to realize also that much work was done in this dimension of communication in order to discredit all the warnings. And we were told that, of course, but there is principle of subsidiarity. So only very small part
we
of
trust rule of law of the European institutions.
Also, so one of the topics in Poland was about the identity of marriage. That it is subsidiarity, that there is no threat to marriage as a union of yes, and today we can see that it was only some fairy tale, some narrative to make us asleep and not to to rise our consent to this process. Of course, the situation is much more complicated because it was also decision how we consider our statehood in the relation to the neighboring countries, yes, with whom we are going to cooperate, on what basis we are going to cooperate. We profited much from the common market, from being part of this common market, but those profits has also its costs, and it appeared that suddenly that the cost cost us our identity.
I rephrase my previous question because I would like to get to the point whether it is a necessity to be in the club in order to realize these developments or these trends, or is it possible to realize them in advance when you are still outside? Often I'm surprised by the awareness of those professors who are coming from countries which are not yet member states. They are just in the process of accession, and most of them who are cooperating with the Central European Academy are so awakened, so they are clearly seeing those dangers to the sovereignty, but also the politics of the accession process often eliminates the sovereign member state to act in line with their own national interests, which up to a certain point, based on the compromise philosophy, is acceptable, but beyond certain line, it's not. And again, coming back to Poland, did you see any point in time after accession of revelation of the Polish society when they started to feel what is going on?
Now that this change in social consciousness is taking place with the migration crisis, with the energy crisis, with when it appears that we've got big resources of the coal, which is perfect source of energy, but the energy in Poland is the most expensive in all the European Union because of artificial taxes imposed on those non-green sources of energy, etc. So people now started to realize more and more about the costs, but we are just at the beginning of this process.
As a lawyer and professor of a university, do you have a definition for constitutional identity? And if yes, what are the specificities for that in Poland? What are the special character of Polish constitutional identity?
First, we have to realize that all our European constitutions are very similar, actually. Threefold division of power, rule of law, principle of legality, human rights, human dignity, etc., etc. These are all common fundamentals, and within this common denominator we've got some specificities. But these specificities are much less important. Yes, they are kind of colors of the same car. Yes, you are buying the same car, but you can choose your color. So I would say in this respect, of course, there are questions. Perhaps it is really worthy to quarrel about colors and to choose the proper one. Of course, there are. So our identity means our specificity, something which makes us distinct from the others. Yes, and so there is the question of this distinctiveness, what is so important to Poles that they want to differ in this respect. Of course, in every nation state, in every national country, the language is such a factor, and the culture which grow over this language. Yes, literature, and but not only, of course. And today, indeed, those issues which culture issues in understanding human being, the beginning of life, human life, and the extent of protection to human life, the identity of the marriage, yes, identity of family, and the degree of autonomy that should be provided to the family. Then the question of the relationships between state and the church. Yes, these are issues which could be drafted in our constitutions in a specific way because of our historical experience, our tradition, our history. But this operating engine is very much the same, very similar, and it is made also more and more similar by the European Court of Human Rights, by the Court of Justice of the European Union. This their jurisprudence, their case law, providing us some common ground for communication, and also being some certain goal to be achieved in the future. So those this dynamism towards centralization, towards unification, homogenization, yes,
uniformization,
is predominant.
Time is running so fast, dear professor, so we have to approach the closing part, and all the issues which we actually tackled are, not all of them, but most of them are contained in these beautiful books, which are part of the series of the books of the Central European Professors Network. So I'm very happy to have you as our long-standing partner. And in the closing part, I often ask...
My pleasure.
Ask our cooperating friends why they would recommend the Central European Academy for their students back home in Poland. What is the added value coming to take part in our PhD program or in our LLM programs or even as lecturers? So what is, in your view and based on your common experience?
Well, this specificity of Central Europe exists, and I think it is very important for us to know each other, to better communicate with people from Central European countries, and not to neglect those relationships, giving the priority to contacts with Western countries, with Germany, France, England, Spain, etc. So it is very much important, in my opinion, to meet people who live in a much more similar conditions, cultural conditions, with whom we could share more values than with the others. This idea, which is expressed somehow, which is finding its expression in Central European Academy, of taking focus on Central Europe, is very precious. And yes, I would recommend to everyone interest in the Central European Academy activity, perhaps also joining some PhD programs or LLM programs. Really, it is worth to do it. And I think Central European Academy is also the place where some not uniformed, not homogenized opinions could be met, discussed freely. So it is very, very precious, especially for scholars from Western Europe.
And this is the point.
Yes, they came to Poland or to Hungary and they say, well, it would be impossible to discuss so openly those topics in my country.
Yeah, actually, we created a forum where all views are accepted, and the dissemination is a very important tool for us to be heard. And this is why these beautiful publications are open access on the internet. And we already had nice experience when we were called from the US. They found one of our books and studies on the internet, and they would like to cooperate with us in studies concerning family law, for example. So dissemination is key, because we should be heard by our Western scholar partners. And here we are very proud of each other's, let's say, national identity. Mm-hmm. And this is how we share our experience, we find our commonalities, and which is more valuable in the cooperation of the Central European Academy is the friendship and the network and the people. Because books are just books, publications are just paper or internet format, but these are the personal and professional relationships which matter, and our approach is to invite and attract as many high-level professionals from among these countries, so that they can recommend to their students in their own circles, in their own country. Dear Mr. Stępkowski, the last question is always a game in the interview, in this podcast. If I came from another planet and I did not know anything about your country, not even about Europe, what are according to you, the 3 or 4 main messages or important information about Poland which I should know?
Well, if you come from different planet, you would have such a small amount of information that. Poland is the country of people who oftentimes still believe. Oftentimes still believe that the source of our reality is transcendent. So strong family, relatively strong family, I have to say, because family is becoming weaker and weaker, but still, and beautiful nature, and the sea and the mountains and the lakes and the forests. So beautiful people. And quite a precious culture heritage also. So we are still preserving this, and everyone who is going to who like it is well seen, well appreciated. We are very open to visitors, especially to Hungarians.
Actually, we are a great fan of Poland, and the very basic cooperation was the Hungarian-Polish axis between legal researchers. So thank you very much, dear professor, dear ladies and gentlemen. This was the podcast episode with Mr. Professor Dr. Aleksander Stępkowski from the University of Warsaw. It was our pleasure. Please follow us on the social websites and social media platforms, and we see each other in the next episode. Thank you very much for your attention.
We hope you enjoyed this episode of Central European Legal Insights. Don't forget to follow us on our social media channels for updates. To discover more conversations from the series, be sure to explore our other episodes. Thank you for listening.